Welcome back to Last Touch Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss what constitutes a seizure of a person under the Fourth Amendment by looking at a very interesting set of facts. Officers were trying to make an arrest of an individual outside of his home. When that person arrived, they made the arrest, but they really wanted to search the house. So what did they do? They waited for the wife to arrive. They intercepted her about 2 blocks away from the house. One officer got in the car with her, asked for consent to search the home, which she provided, and they later found some incriminating evidence against the husband. So the question becomes, was that consent voluntary? Or was she illegally seized when the officers got in her car? And before we go on, I want to thank you for watching my videos here on YouTube, pushing that subscribe button, and sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please consider giving my podcast a 5-star review rating. And finally, if you want to support this channel, go to lastdash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lawstash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States v. Fox, which is a 10th Circuit decision, and it deals with a seizure of a person and consent to search a home. But first, let me give you some factual background. 4 officers wearing plain clothes and driving unmarked vehicles were surveilling a home around 10 p.m. They knew from a confidential informant that Mr. Fox was driving a vehicle that was stolen, and he potentially had narcotics on him. They also later learned that Mr. Fox had an outstanding warrant. So while observing the house, they saw another individual, a woman driving a black Mustang, arrive to the house. She got into the home, and about half an hour later, she walked out of the house and drove off. This was Miss Chiles. She was Mr. Fox's wife. Now, as she left, the officers were able to make an arrest of Mr. Fox, who returned a few minutes later. Now, as time passes by, Miss Chiles returns back home, and as she drives up, she sees a bunch of officers, so she gets intercepted by 2 of the officers. As she gets intercepted, she asks one of the officers what's going on. Now, this police officer provided his badge. He showed her that he was in fact a police officer. He then got into her car and directed Miss Chiles to a nearby parking lot where they could talk. Now, he got actually inside the vehicle and drove with her to that particular parking lot. There, he explained to Miss Chiles what was going on. He asked her to get out of the vehicle and provide her driver's license. Now, she didn't have a driver's license on her, so the officer had to call the dispatch and get some information on Miss Chiles. While she was waiting on the dispatch, the officer asked Miss Chiles if there was anything illegal in the car, and she said that she didn't have anything illegal in the car. He then asked her if she minded if he looked real quick, and she said, "No, go ahead, there's nothing to hide." The officer then looked around the front compartment of the car, found a bag that contained what appeared to be methamphetamine. Although the substance was not field tested, Miss Chiles acknowledged that it was an illegal substance. Chiles was not arrested and was told by the officer that the police were more interested in Fox. She replied that Fox was her husband, as we already know that, and that they lived together. The officer then asked Miss Chiles whether she was on the lease and could provide consent to search the home. She responded that it was fine to search the house because, again, there was nothing to hide. The officer then took Miss Chiles to the house. She opened the front door and let the officers in. Once inside the house, the officers asked if she would sign a search waiver form, and she said that she would. But the officers didn't have one, so instead they began the search. They found some incriminating evidence, and after they found it, they then had Miss Chiles sign the consent to search form. What did they find in the house? Well, they found a sawed-off shotgun and some ammunition. As a result of this search, Fox was indicted on one count of being a felon in possession of a firearm and ammunition in violation of 18 U.S.C. 922 G1, and one count of possession of an unregistered shotgun with a barrel of less than 18 inches long in violation of 26 U.S.C. 5841 and some other statutes. Now, what happens after that is he files a suppression motion. He says that the search of the house was illegal in violation of his Fourth Amendment rights. The suppression motion gets denied. He enters what's called a conditional plea, where he pleads guilty, but he's able to then go to the appellate court and argue for that suppression. He receives 48 months of custody time. He appeals to the 10th Circuit, and he argues that the search was illegal once again. We know that the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search, unless one of the articulated by the Supreme Court exceptions apply. Here the government relies on the exception called consent. Now the government says that Ms. Chiles consented to the search of the home, while Mr. Fox says that's not true. The search of the home was illegal because the consent was tainted by the illegal seizure of Ms. Chiles. If the officers never intercepted her and got her into the vehicle and essentially quote-unquote seized her, then they would have never received that consent. So the first question, of course, becomes whether she was illegally seized. Courts have identified three general categories of encounters between police and citizens. Number one, consensual encounters which do not implicate the Fourth Amendment. Number two, investigative detentions, which are Fourth Amendment seizures in limited scope and duration, and must be supported by a reasonable suspicion of criminal activity. This is what are so-called Terry stops. And number three, arrests, the most intrusive of Fourth Amendment seizures, and reasonable only if supported by probable cause. A person has been seized within the meaning of the Fourth Amendment only if, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that she was not free to leave. The critical inquiry is whether the police conduct would have communicated to a reasonable person that she was not at liberty to ignore the police presence and go about her business. In determining whether an individual has been seized, the courts have considered several factors, including number one, the threatening presence of several officers. Number two, the brandishing of a weapon by an officer. 3, physical touching by an officer. Number 4, aggressive language or tone of voice by an officer, indicating compliance is compulsory. Number 5, prolonged retention of a person's personal effects. We have discussed that many times throughout the last couple of weeks, where the officers take the individual's driver's license, for example, and never return it throughout the encounter. Number 6, a request to accompany the officer to the police station. Number 7, interaction in a small, enclosed, or non-public place. And finally, number 8, absence of other members of the public. We can all agree that the initial encounter between the police and Ms. Chiles was consensual in nature and does not implicate the Fourth Amendment. It was Ms. Chiles who stopped on the side of the road and asked the officers what was going on next to her house. But that encounter quickly became a seizure. The officer showed Ms. Chiles his badge, identified himself as a police officer, got into her vehicle, and then directed Ms. Chiles to a nearby parking lot. Throughout the encounter, he did not tell Ms. Chiles that she was free to leave, and with this sort of coercive show of authority, no reasonable person would feel free to leave. Of course, no reasonable person would tell the officer to get out of the vehicle, and once they're at the parking lot, no reasonable person would drive off. So here, Ms. Chiles was in fact seized under the Fourth Amendment. The next question becomes whether this was an illegal seizure. Not all seizures are illegal, but here, at very minimum, under a Terry stop, officers need to show that they have reasonable suspicion that criminal activity is afoot to make a brief detention. And here the government cannot show that Ms. Chiles committed any sort of crime. And we all acknowledge that the government was interested in Mr. Fox and what was inside the house. They were never interested in Ms. Chiles. Even later on, when they found drugs in her car, they still didn't make that arrest. But really, we need to focus at that initial encounter, when the officers direct Ms. Chiles to the parking lot. At that moment in time, they had no reasonable suspicion that Ms. Chiles committed any sort of crime. And that being said, Ms. Chiles was in fact illegally seized under the Fourth Amendment. The next question becomes whether the subsequent consent was voluntary. And of course, Mr. Fox argues that the consent was tainted by the illegal seizure. To demonstrate, however, that the taint of an illegal seizure has dissipated, the government must prove from the totality of circumstances a sufficient attenuation or break in the causal connection between the illegal detention and the consent. This is a heavy burden. In Brown v. Illinois, the Supreme Court articulated 3 factors especially relevant to this inquiry. Number 1, the temporal proximity between the police illegality and the consent to search. Number 2, the presence of intervening circumstances. And particularly number 3, the purpose and flagrancy of the official misconduct. Quickly running through the Brown factors, the first one, temporal proximity. Well, we know that the consent happened almost immediately after Ms. Chiles was detained by the officers. Of course, she spends a little bit of time in the nearby parking lot while the officers are trying to find her identification information from the dispatch, but she almost immediately is taken to the house and opens the house for the officers to search. So we know the consent happened almost immediately after the initial encounter with the police. The second factor, if there are any extra circumstances or events that would break the causal connection, well, here there was no other events that broke the causal connection between the illegal detention and the consent. Some of those sometimes include, for example, an arrest and release, or some other officer explaining to the individual that they have right to withhold their consent. Nothing of that sort of nature happened here. And finally, the third factor, the misconduct of the officers and whether that misconduct was purposeful. Here we know that of course it was purposeful. The officers got Ms. Chiles to that parking lot in order to find out whether she owned the house, whether she could consent to the house, and whether she would consent to that home, to the search of the home. And she in fact did. Not only that, the officers found incriminating evidence against Ms. Chiles, and they still didn't arrest her because they were interested in the search of the home. Well, because we just ran through all the 3 factors under Brown versus Illinois, we know that attenuation doesn't apply. And so the consent was not valid. It was not voluntary. In the conclusion, here's what we know. This was an illegal seizure of Ms. Chiles when the officers stopped her and directed her to a nearby parking lot without any reasonable suspicion. This was an illegal seizure under the Fourth Amendment. And because we have an illegal seizure, the consent that followed is not voluntary. There is no attenuation here. So all the evidence against Mr. Fox should have been suppressed in the lower court, and now this case will be remanded there, where all the evidence will be suppressed and all the charges should be dropped. If you enjoyed this video, if you learned a little bit more about what constitutes a seizure of a person under the Fourth Amendment, how the attenuation doctrine works, I hope you hit the thumbs up button, click the subscribe button to my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts. They work. Thanks for watching.